you're driving around with a 2-year-old in the vehicle and you're acting like a maniac. And I could see the terror on their face just looking at them. And then you blow us off with probation. Like, I'm the kind that's going to put up with that.
This case is absolutely unbelievable. A high-speed crash, a terrified family barely escaping with their lives, and a shocking twist involving a child left in danger. Where was he? Today, we're diving into a courtroom moment where the truth slowly unravels, contradictions come to light, and a judge reaches a breaking point. But here's the real question. Is this a case of reckless disregard or something deeper? Stay with us, because what happens next will completely change how you see this story.
3 cases. I have people against Jeremy Javon Christian, 21B139004. That is from a date of June the 13th of 21.
Right from the start, the court lays out a pattern, not just one mistake, but multiple legal issues stacking up against the defendant. We're talking reckless driving, resisting an officer, and even a probation violation tied to impaired driving. Now, this is critical because when courts see repeated offenses like this, it shifts the focus from a one-time lapse in judgment to a potential pattern of behavior. And that changes everything when it comes to sentencing. So ask yourself, should past mistakes weigh heavily in a case like this, or should each charge stand on its own?
On an operating while impaired charge, which the defendant was sentenced on back on March the 17th of 21, I believe. Yes, March the 17th of 21, and then did not show up for a probation violation hearing on September 8 of 21. So I can take them in whatever order you want to go.
If the court wants to start with the reckless driving,
We'll do that. And the resist and obstruct. So everybody can state their names, please. Your name, Mr. Gaith?
Good morning, Judge. Nice to get from back, Mr. Christian. Mr. Christian, say your full name.
Christian. All right, your names, please.
Diane Barbarich.
Lawrence Barbarich.
Adam Barbarich.
All right, so the June 13, 21 incident, there was a no contest plea, and they failed to appear for sentencing at least once or twice. And so we haven't had them here, but at any rate, I did not order on that
The PSI.
I didn't order a PSI, I don't believe. So I just set a sex date so the victims could be notified. They were, and then it looked like he came in on August the 31st.
Here's where the defense tries to humanize the situation. Homelessness, injury, job loss, and financial struggles. These are real-life hardships, and courts do consider them. But there's a fine line. Hardship can explain behavior, but it doesn't always excuse it, especially when public safety is involved. And remember, this case involves driving over 100 miles per hour and causing a serious crash. So the big question becomes, how much should personal struggle mitigate responsibility when others' lives are put at risk?
Christian at that time had become homeless. He was homeless from 22 through 25. He was laid off. And then he ended up, there was an incident in which he was shot in the hand, and he became disabled for 6 months and unable to work. Then he became laid off and actually just went back to work about a month ago at Chrysler. He does have an 8-year-old child that he shares custody with the mother, and he was financially responsible for that child, Judge. And between his lack of stable residence and everything else that's been going on, I believe that's the reason why he had missed and failed to appear in that direction.
Okay. Anything else?
Just that, at the time that he took the plea, obviously, looking back now, I know it did indicate that he would maybe have pled differently, but I did advise him that we're at this point now and we need to move forward.
Now we hear directly from the victim, and this is where the emotional weight hits hard. Imagine being a teenager, sitting in the back seat, and suddenly your world turns into chaos. Spinning, crashing, fearing for your parents' lives. This isn't just an accident. This is trauma. And what stands out here is how close this came to being fatal. The word miracle isn't used lightly. Moments like this remind us just how fragile life is and how quickly reckless decisions can change everything.
I want to say it almost just feels like a miracle that we're alive, because I mean, I was sitting in the back seat when it happened, and I was like 16 at the time, and we were coming back from a long weekend of baseball, and we're all tired, and we're just trying to get home, have a 3-hour drive, and we're just driving in like one of the middle lanes. Maybe it's like a 4-lane highway, and I'm on my phone, just kind of leaned over in the back passenger seat, and then all of a sudden it's just big bang, and it just felt like we were spinning forever, just spinning on the road. And I don't know how we didn't get hit. It just feels like a miracle to me. And we went across, it was a lot of traffic. We went across the whole lanes and slammed into the median. And I was scared for my parents' lives. I was fine. The first thing I asked is, are they okay? And I think they hit their head.
And then comes a shocking detail. Witnesses claim the driver was speeding for miles, almost as if a crash was inevitable. That introduces a disturbing idea. Was this just reckless or completely indifferent to the danger? When multiple bystanders notice the same behavior, it strengthens the narrative that this wasn't a split-second mistake. So what do you think? Does this sound like negligence or something even more serious?
And made sure my parents could get out. And we got out, and first thing I noticed, I look at the car, and the tire was catching on fire. And I was able to put it out before it caught the whole car on fire. And, it's just like these little things like this. It's just a miracle to me and makes me look at life completely different now. Um, and I had no idea what happened. And we had people coming up to us, and they were saying that, this guy hit us. He was speeding down the road for miles. They knew they were going to hit somebody. And then they said he went off the road, further up the road, and somebody said that they had a kid in the back of the seat. I couldn't believe what was going on.
This is a key legal moment. The judge explains what a no contest plea means. A lot of people misunderstand this. It's not an admission of guilt, but legally, it has the same effect when it comes to sentencing. It's often used to avoid civil liability later. So while the defendant isn't saying, "I did it," the court is still treating it as if he did. That nuance is incredibly important, and it can have major consequences down the line. The father's statement adds another layer of gravity. A retired firefighter, someone who's seen real tragedy, admits he was afraid to look back at his own son after the crash. That tells you everything about how severe this moment felt. When someone experienced in emergencies is shaken like this, it speaks volumes. This wasn't just another accident. It was a near catastrophe. Now we shift into probation violations, and this is where things start stacking up fast. Missed appointments, failed programs, unpaid fines, substance use, it's a long list. Legally, each violation may seem small, but together they paint a picture of noncompliance. And courts take that very seriously. At some point, it's no longer about giving chances, it's about enforcing accountability.
Impaired. I've got multiple violations. Failure to attend the scheduled probation visit on August 18 of 21. Failure to attend the victim's impact panel. Failure to attend the court work program on August 4 of 21. Failure to pay fines and costs as ordered. Failure to refrain from consuming alcohol or drugs, testing positive for alcohol on August 3. Failing to clear all warrants. Failing to provide verification of attending AA twice a week until an IOP, and failure to provide verification of attending and completing outpatient treatment. So I'd like to either have a hearing on those or take a plea on those, whatever he fancies. So how's he going to proceed on that?
You can't take a plea.
Is that what you want to do, sir? Since you absconded, you could get 93 days here. Do you understand that? You got to keep your voice up for him. You are presumed innocent. They have to prove you guilty, Bell. By a preponderance of the evidence, you have the right to question their witnesses.
Listen closely here. The defendant is pleading guilty to multiple violations, one after another. This rapid sequence matters. It shows acknowledgement, but it also confirms the extent of the noncompliance. And when someone admits to this many violations in one sitting, it can heavily influence how the judge perceives their credibility and commitment to change. So the question is, does this come across as honesty or damage control?
To attend your scheduled probation visit on August the 18th, 21, how do you plead?
Yes.
Did you fail to attend your probation visit on that day?
Yes, sir.
Count 2. Did you fail to attend the victim's impact panel? How do you plead?
Yes.
You failed to attend the victim's impact panel.
No.
You went to the
Oh,
victim.
yes.
Not when it was assigned, Judge, but he did make it up. But at the time, yes, he did fail.
Did you fail to attend back when you were on probation?
Yes.
Or in that time frame when you were given?
Yes.
To count 3 that you failed to attend the court work program on August the 4th of 21, how do you plead?
Yes.
Did you fail to attend the court work program on that date?
Yes.
To the charge you failed to pay your fines and costs as ordered, how do you plead?
Yes.
Failed to pay your fines and costs as ordered.
Yes.
Count 5 that you failed to refrain from consuming alcohol, testing positive
Yes.
on August 3 of 21, how do you plead?
Yes.
Did you consume alcohol, say within the 3 days before that test?
Yes.
And count 6 that you failed to clear all your warrants, how do you plead?
Yes.
Count 7 that you failed to provide verification of attending AA twice a week until an outpatient, how do you plead?
Yes.
Count 8 that you failed to provide verification of attending and completing intensive outpatient treatment, how do you plead? Did you fail to attend outpatient treatment?
Yes.
Did you fail to clear all your warrants? Did you fail to attend AA twice a week until an outpatient?
Yes.
Intensive outpatient. Anybody force you to plead guilty? Anybody promise you to induce you to plead guilty? Please accept all 8 counts. Heather, I need to know how much he owes on those now.
On his probation case, he has a balance of $813.
All right, now I'm going to ask, and again, all of these would be deemed non-technical since you absconded. So you got 8 non-technical violations. Is there anything you'd like to say
Judge, with
on
regard,
any of these?
with regard to count 2, failure to complete the victim impact panel, he did complete that.
The defense continues to emphasize financial struggles as the root cause. Unable to afford treatment, struggling to pay fines, difficulty maintaining compliance. And while financial hardship is real, courts often expect individuals to communicate and make partial efforts. Silence or absence tends to hurt more than help. So it raises an important point. How much responsibility lies on the system, and how much lies on the individual?
Balance. With regard to count 5, he's pleading guilty as charged with regard to the positive test and the alcohol. With regard to count 6, Judge, the warrants, according to Mr. Christian, he's cleared the majority of them. He believes He does have three or four that are left outstanding. And that's only been a financial issue because he hasn't worked. He's only been back for like a month. With regard to counts 7 and 8, he wasn't able to get into the outpatient treatment program because his insurance wouldn't cover it. And again, Judge, financially, he wasn't able to afford to pay for that out of pocket. He's trying to make up for whatever he was able to do now. But again, Judge, mainly it wasn't so much in somebody's going to the court other than his being financially unable to pay for these and get them cleared. It was a financial issue.
Anything you'd like to say?
And I'm still currently actively trying to get taken care of my life. As far as my license, I'm trying to get my license back, but I can't get my license back because of directed driving to the year. It's the only suspension that's holding me back from getting my license. So I've talked to Secretary of State about what happened that, and the other activities that I have are for a driver suspended license. So once I get my license, we go back in, try to see this what you have.
Well, Janine,
Elizabeth Prosecution.
anything you'd like to say?
Yes, Your Honor, and I might be able to offer up at least a little bit of clarification, maybe even some help from Mr. Christian. So he was in front of Judge Hessen. I don't know if this was already addressed, but he was in front of Judge Hessen July 11th of 24. She reiterated bond conditions. He did come down to probation on July 11th. I re-instructed him in regards to his treatment, chemical testing, and I did schedule him for 3 days on the court work program. He was instructed on 12-step meetings at the time as well. So as of that time frame, he was given a court date then to come back August 28th. He absconded and the bench warrant was reissued. Between that July 11th date and August 28th, Mr. Christian did do the 3 days on the court work program.
Was she talking about, I see that she was the one at one point that arraigned him on this charge, these charges. Was that court work that she told him to do, was that on these cases or was it on a case in front of her?
Not on a case in front of her. This was addressing her bond on the probation case, which would have been this one here. Judge Hessen will often reiterate probation terms as part of bond. And she ordered the 3 days on the court work program because those were the days he had remaining out of the 4 that he was to attend.
He had gone to one before that?
He had done one on August 4th, 21.
So he actually has 5 days credit coming on these.
He has 4 as far as court work program.
Plus the 1 day credit for the arrest.
He did show for 1 chemical test after bond. He was positive for marijuana, negative for all other substances, but absolutely no proof in regards to victims impact panel, 12-step meetings, or treatment.
Judge, he does have the certificate of completion for the victim impact panel.
Okay. Do you have that with you, sir?
It's in my phone. I think I have a login. So I have.
I'll take it your word on that.
See.
No, I'll believe you. Folks, would you like to say anything else? Yeah, you could say something to them.
To you, I'm sorry about the event that happened. It was very foolish on my behalf. And since then, I've learned I know I do it. I had a younger child at the time, and I understand the pain, kill the younger child. I just want to say that I'm sorry.
Where are you going to school at, young man?
University of Northwestern Ohio.
Well, what are you studying?
This moment changes everything. A claim is made that the defendant left a 2-year-old child behind on the expressway. An absolutely shocking accusation. But then, immediately, it's corrected. The child was actually taken to the hospital. This is huge. It shows how quickly misinformation can escalate emotions in a courtroom. And it reminds us, details matter. Because one misunderstanding can completely shift how a case is perceived.
The defendant, he had a 2-year-old in the car, in the back seat, and he ran from the scene. I was told by bystanders. And I guess some bystanders tackled him or something that I can recall, but I can't even imagine that, leaving a 2-year-old on the expressway like that and just running away. That was on top of what happened to us, but I just wanted to say that too.
Judge, I want to correct the record. Actually, his child, when he left, he wasn't running from the scene, Judge. He actually took him and they went into the ambulance and they were taken to the hospital. So I don't know where the information came from that he was tackled, but he actually went to the emergency responders and actually got in the ambulance with his child and they were transported to the hospital.
Okay, so I want everybody to understand, unless somebody speaks up and says, Judge, we have this much coming in restitution, I'm not going to order any. Does everybody understand that?
Yeah.
Well, I'm talking to the victims.
Now the judge reaches a breaking point, and you can hear the frustration. This isn't just about the crash anymore. It's about years of missed court dates, ignored responsibilities, and what the judge sees as a lack of respect for the system. When a judge uses words like, "You blew us off," that's a strong signal. The tone has shifted from evaluation to judgment.
I don't know what to say to you, Mr. Christian. There's a whole lot of issues I have with your conduct, your failure to appear, your failure to show any respect for the court. And the more I look at this, and the more I think about this, I mean, this is laughable talking about whether or not you get another day off or you have to wanted to wait till May if I was going to adjourn it past today because of a vacation. Or lack thereof, vacation time. You can't do this. You cannot do this. You cannot do this. You're driving around with a 2-year-old in the vehicle and you're acting like a maniac.
And just like that, the sentence is handed down. Jail time across multiple charges, probation revoked, and financial penalties imposed. The judge makes it clear, this isn't just punishment for one incident, but for a pattern of behavior that couldn't be ignored any longer. In the end, this case highlights the balance courts must strike between understanding personal hardship and protecting public safety. So what do you think? Was this sentence fair or too harsh? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
15 days jail on the resist and obstruct, and that will run with concurrent with 21B138482A. I'm going to give the defendant 45 days jail on the reckless, and that will run concurrent with 21B138482A. On the operating while impaired, I'm revoking your probation. You're to pay costs in the amount of $800 and serve 93 days, credit 5 for 88. If you pay 800, so if you get somebody to bring up 800 or sign over their bonds, that will suspend 18 of the 88 and you'll only have to serve 70. But you're in custody for 70, you pay 800. They will all run concurrent, Heather. Yep. You pay 800, you'll be out in 70. Otherwise, you're going to be in for 88.
Should I be out in 70?
70. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Yeah, we're going to let you make a phone call. I'll let you. There's nothing I'm going to do. You spat on the court. You drove like a maniac. There is nothing I am going to do to change my mind. The only thing I could do or would do, if I could, is call the legislature and tell them to retroactively make this a lot more serious, because I'm only giving you that because that's all I can give you. There's nothing I'm going to do to change, you're going to do to change my mind. So I'm going to ask you not to speak. You can talk to a lawyer on appeal if you want. You can't blow off courts for 3-4 years, and you just can't do that. So there's nothing else. Have a seat. Good luck. Thank you very much. Thank you, folks. Have a good day, and I wish you all well.
Thank you.